three orders. Let me put it that way. One, and I'm reading now, it says, Chairperson, thank you, Mr. Mpofu. Then it says, the application for postponement for the hearing, Mr. Mokhesi, evidence is dismissed, which is what I've just addressed. So that's number one. Number two, reasons can be given in due course if they are requested. And I want to say on the record that we will not request any reasons, because the reasons would be just one sentence that there was no longer an application for postponement. But here's the important part. Number three, this is what the chair said. Mr. Mokhesi will need to take the witness stand, but he will be able to exercise his right with regard to specific questions, not to incriminate himself. His right to refuse to answer certain questions. Okay, thank you. And that really was then the outstanding matter. Now, in our view, well, as Mr. Pretorius has just indicated, he then went on and then he needed another 2 hours or so, and the chair gave an extra hour. I'm glad to commit Mr. Pretorius that today he has promised me that he won't go beyond 1 hour. Otherwise, I will object on that basis alone.
Well, if he goes beyond 1 hour, he'll blame questions from the chair.
Thank you, Chair. Yeah, that's why I'm selling him out here. Then, Chair, on a more serious note, we wanted to place on record that Mr. Mokhesi, it has come to his attention that the Hawks have been asking certain questions from people at his workplace. And I won't go through them, Chair. They are in paragraph 7 of the note. But our concern is simply that these questions seem to be largely based on the evidence that he gave here, which is one of the things we feared. And we're really placing that on the record just to reinforce our fears about self-incrimination. But for the rest, Chair, we are really here for basically to police Mr. Pretorius. If he asks any question that goes beyond the agreed parameters, but which we don't expect, yes, then we will object. Otherwise, it should go quite quickly. Chair.
Well, I think, Mr. Mpofu, last time I think I placed on record, and if I didn't, I would do so now. Yeah. That my impression was that there was a lot of cooperation from both your side, Mr. Mokhesi's side, and to try and answer as many questions as possible. I think we made a lot of progress.
We did. Yes.
If I recall correctly, and I may be wrong, there was only one question that he had difficulty with. So there was a lot of cooperation, and I think that needs to be said.
Thank you, Chair. I will appreciate that. Yeah. Then, Chair, just again, this is completely unnecessary, but just for the record, one of the issues I was going to address was we had received a Rule 3.3 notice in respect of the evidence of a Mr. Koloi, who was supposedly going to implicate Mr. Mokhesi. Mr. Pretorius has now assured me that that gentleman is no longer going to be called. So that issue, okay, I don't need to address that.
Okay,
issue.
No, that's fine.
Thank you, Chair.
That's fine.
Thank you very much, Chair.
Thank you, Mr. Mpofu.
Thank you, Chair. There's not much that I should add. Safe to say and to make it clear that whilst a witness has protection in relation to self-incriminating questions, there's nothing in the law or regulations, either statutory or common law, that prevents the law enforcement agencies of investigating in relation to other persons the answers given, and that evidence may be used against other persons.
All right, thank you. I think we must do the oath again, or affirmation.
Please state your full names for the record.
Nthimotse Mokhesi.
Do you have any objections to taking the prescribed oath?
No?
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Good morning again, Mr. Mokhesi.
Morning, Mr. Pretorius.
Would you please look at bundle FS8? And if you would go to page 180, please. You will recall
180.
180.
180.
Remember the black numbers on the left-hand side, please.
I'm still waiting for mine, Mr. Pretorius. They put here another one. Thank you. I've got it.
Yes.
We concluded your evidence on the last occasion in relation to the asbestos project, Mr. Mokhesi, by referring to the letter on the previous page addressed by yourself, dated the 11th of August 2014, to Mr. Sodi, the CEO of Blackhead Consulting Pty Limited.
Yes. Yes.
And if you look at the subject line, your letter says to him that this letter concerns the appointment of Blackhead Consulting Pty Limited for the asbestos eradication program in the Free State Province.
Yes. Yes.
You then referred to that letter in your reply, and that reply appears, I'm sorry, that's your letter to him. The reply comes from Mr. Sodi, the CEO, Blackhead Consulting, and that appears at page 180.
Yes.
That's a letter addressed by Mr. Sodi to yourself, Department of Human Settlements, Free State. It's dated the following day, 12 August 2014.
Yes.
It's on the letterhead of Blackhead Consulting and Diamond Hill Trading 71.
Yes.
And the subject line is appointment of Blackhead Consulting Pty Limited JV for the asbestos eradication program in the Free State Province. And the first paragraph reads, "We acknowledge receipt of your fax dated 11 August 2014, in which you request our written response regarding the appointment of Blackhead Consulting Pty for the asbestos eradication program in your province." You will notice that Mr. Sodi pertinently refers to your letter of 11th of August 2014, which deals with the appointment of Blackhead Consulting Pty Limited, we can read in, correct?
Yes.
He then says to you, "We would like to confirm the following, that Blackhead Consulting Pty Limited JV is willing and committed to perform the required work for the Department of Human Settlements in the Free State. 2, that the participation of Blackhead Consulting Pty Limited JV shall not negatively impact on its performance towards the Gauteng Provincial Government." We know, of course, that the JV had nothing to do with the Gauteng Provincial Government, But I just wanted to point out that this appears to be the first mention in the string of correspondence that we've been dealing with of the joint venture. Do you see that?
Yes.
The identity of the joint venture inserts itself into the string of correspondence regarding the appointment, ultimately, of the JV at this stage for the first time. Before this, it's been Blackhead only. After this, it's the JV. Correct?
Correct.
And as recently as the previous day, the 11th of August 2014, you were speaking of Blackhead Consulting Pty Limited.
Correct.
Did you notice the change?
Well, I did not. When I look at, I also had indeed looked out at the correspondence throughout, and just to try and find out why it did not change, why all of a sudden, you know, particularly from this particular date, why it changed. I then noticed.
Remember to look this side.
Sorry.
Mr. Mokhesi.
Sorry, Chair. My apologies.
Yes.
I
Just
then,
start your answer
Okay.
fresh, please.
I'm saying, as Mr. Pretorius has indicated, all the letters and the correspondence to different people and so on has always been Blackhead Consulting Pty Limited. Not at any stage has there been mentioned in the AG. So I went back and tried and find out how did it come about. Now, up around about that particular time, whether it was the 10th, there's a document which has been signed between the parties, which I was not a part of, which has been signed around that particular time between Mr. Mpambane and I think Mr. Blackhead and Diamond Hill in their respective capacity around the issues of JV. But then and if you notice that subsequent to that, then came this issue of JVs and so on. But suffice to say, on my side, I had somehow assumed that Diamond Hill must have been part of the Gauteng project, which turns out that that was not the case at a later stage.
Well, it seems that the letter in its detail and even the letterhead was not properly had regard to, because I think you fairly conceded elsewhere in your statement that things might have been different had you noticed the intervention of the joint venture at the stage.
Yes.
But I don't want to go there right now. Just to say that had those responsible, and it's not necessary at the moment to point fingers at any particular person, but to the Department of Human Settlements rather, and its procurement process. Had the introduction of the partner, 50% partner, been noticed, the question might have been asked, well, why are you introducing partner to get 50% of the payments that are going to be made by the province? And is this not inflating the price unnecessarily? Seems to me that inquiry was not made.
No, it was, no.
And had it been made, it would have been discovered that, let alone Blackhead's performance, Diamond Hill Trading were doing nothing of note to warrant the payment of 125 million rand. That inquiry wasn't made.
Yes, I think also my earlier statement, Mr. Pretorius, where I had indicated that, you know, there was a fundamental issue that was not addressed of getting documents, because it was only through that process.
Please raise your voice, Mr. Mokhesi.
I'm saying There's a fundamental issues that never happened. I think earlier on I indicated that there were 3 issues that could have assisted here. The first, the most fundamental one, despite the fact that the Treasury regulations does not require of that, but there is a underlying, particularly on the risk management, to say if the procurement or the supply chain had taken the trouble of getting documents, a lot of issues could have been picked up, including what Mr. Pretorius is raising right now. So because that did not happen, and those issues were not picked up. So this is what I'm trying to indicate.
But would you not accept that, quite apart from any obligation that officials dealing with supply chain management in the department may have had to apply their minds to that issue, that you as the head of the department had an obligation to apply your mind to such an issue and to satisfy yourself that what was being done was in line with the law? Would you not accept that as the HOD you had that obligation as well?
Yeah, Chair, how far, maybe I should have gone further, because as I've indicated earlier, the supply chain practitioners of government are trained. They attend workshops almost on a monthly basis. The practice notes that come from Treasury goes to them. They advise us in our management meeting about the new issues and what is happening now. Here I'm indicating about an individual who also has experience, who has worked in that environment over time. Now, and one tends to trust, because I know this individual. I've known him for quite some time, even when he started. So one tends sometimes to trust. As I've indicated, to sometimes pick up these particular issues when there's a problem already, like we are facing right now. So I accept perhaps maybe I should have done more, but it was a level of trust that I'd had on the individual.
Okay, Mr. Pretorius.
Mr. Mokhesi, arising out of that question and answer, it may be with the issue now rather than later, as I intended to do, and that's the question of accountability. We've heard evidence in this asbestos matter and in the housing matter and in other matters too. And the Commission is restricted in its capacity to investigate matters such as this, which are voluminous. What has become clear, however, is that the question of accountability comes to the fore again and again and again. The senior officials lay blame on the junior officials. The junior officials say we were following orders, and ultimately nobody is on the evidence accountable for what happened. Surely there must be a point at which someone says, I am accountable and I am responsible and I must take the consequence. What do you say to that?
Yeah,
it's a general comment I accept.
Yes. The fact that I'm here, I'm taking accountability. And, and indeed, there are consequences for me as we speak right now. I'm not abdicating on my accountability. I might not have been responsible, but I'm still accountable because those officials who are below me report report to me. So in terms of accountability, I'm not abdicating from that, Chair, if I may put that on record. I'm taking accountability for what has happened and also looking at hindsight in terms of what I should have done, you know, and so on, and what lessons can I take from there. You know, this particular issue is happening right at the end of my career. You know, it's not good for me.
Yeah, you see, that's quite important. I hope that before the end of the work of this commission, I'm going to see more and more leaders who, whether it's in public service or political leaders, who are going to say, I've been listening to the evidence, I've been watching and listening to the evidence being led in the commission on a number of things. I've taken trouble to look at this and that and that. I think that, and I have done an introspection on myself because I had a role to play. I was in charge. I was part of a collective that was in charge. And I am here to say, I take responsibility. We fell short. I fell short. Others might not want to take responsibility, but I am taking responsibility. And I am saying, we should have done this, we should have done this, we should have done that, and we did not do it. And we have no good reason why we didn't do it. We take full responsibility. We are taking the lessons. Going forward, we want to make sure this thing doesn't happen again. So I'm hoping that I'll hear some people within our country who will be able to say a lot of things went wrong, and who will stop pushing blame to other people, or at least if they do, they will be able to say, I am also to blame in regard to this, in regard to that, in regard to that. And I'm able to say that in front of the nation, but because I am able to do that, I'm in a better position to contribute to a solution to say what needs to be done in order for this not to happen again. Because if people just deny and don't take responsibility, you can't trust them to make a positive contribution to what the solution should be, because they deny that there's a problem, or they deny that they have a role to play in the problem.
Yeah, Chair, I've certainly made an introspection as well myself.
Yes.
You know, there is a level of accountability in this whole thing, where I said I could have done, there are certain things that I could have done and I did not do.
Yes.
That I accept.
Yes, yes.
You know, even in an accident, you know, they say both of you, there is a level of responsibility for that particular accident. You might you might say that I was right, but you probably, if you have done something else, you could have avoided. So I'm not completely saying and standing aside and saying no. It's not me, it's somebody else.
Yes.
But I'm stating the facts as they are in terms of what has happened.
Yes.
And I've never at any point in time denied that that which was happening was irregular. I haven't done that. I have not denied or tried to defend it.
Okay, no, thank you.
Just a few more pieces of correspondence, Mr. Mokhesi. Over the page, at page 181 of FS8, is a letter from Mr. Tabani Zulu. We know that he was the Director General of the National Department of Human Settlements, addressed to yourself. Do you see that?
Yes.
This deals with the appointment of a professional resource team to a departmental panel So what
Correct.
Mr. Zulu is thinking about, we know that he has to deal with the funding issue in due course. But what he is under the impression is happening is that there's an appointment to a panel or a database, which is talked about later. And he's also speaking about Blackhead, not the joint venture. So he's somehow been informed or drawn conclusions, at least two of which are quite incorrect. We know his participation later is quite important. Do you have any comment?
On the letter of Mr. Zulu to myself.
Yes. He writes to you and he says, on the 13th of August, that's a day after you told the joint venture is the party responsible, and the fact that the joint venture is being appointed itself, not as part of a panel, but as being appointed to do the work. You see that?
Can you read me a specific paragraph, Mr.
Well, just look at the heading.
Just the heading, okay. Appointment
Yes,
of professionals.
Appointment of
Okay,
professional
got that.
resource team to a departmental panel.
Oh, okay.
Yeah.
So that's what you want me to comment on.
Yes, so Mr. Zulu is under the impression that what he's dealing with here and what he will have to deal with later on when he transfers funds is the appointment to a departmental panel. You'll recall earlier correspondence.
Oh, okay.
Not the single appointment of a joint venture or even Blackhead.
Yeah. I think what became clearer later is that you can't appoint on a panel. There must have been an existing contract which was not there.
Yes, I think Mr. Zulu himself conceded that.
Yes.
But was it not important to correct Mr. Zulu to say, firstly, look, we're appointing, or yes, we're going to appoint a joint venture, firstly, as the sole appointee, and we're not dealing with a panel. Was it not important to clarify it for him?
Well, Mr. Pretorius, again, I don't want to be seen as trying to I think the chair has articulated this issue of taking accountability. Yes, I agree. Okay, let me put it that way, to say yes, it was important.
Right, and then, Ms. Mokhesi, on the 11th of September 2014, you address a letter to the Free State Provincial Treasury, which appears at FS 8185.
185.
Yeah.
Yes.
Firstly, now suddenly you are talking of the JV. Do you see that?
Yes.
But what you are also saying here is you are talking about the removal of asbestos or the eradication of asbestos. So what you are saying now to your provincial treasury, who must sign the checks, is that we are appointing a joint venture to remove, to identify and remove asbestos. You see that?
Yes.
Now that's also not correct. They weren't being appointed to remove, and they were being appointed to remove, but we know the fact is that they didn't remove, nor were they asked to remove.
Well, they would have been appointed to, I think there were two phases for that. phase one would have been the audit, and the other phase would have been the removal. The removal did not happen, as we know.
Yeah, the correspondence and the letter of appointment, I think, as well as the agreement, made it clear that there were two, I think, tasks, one of which was the actual removal of asbestos.
Yes.
But of course, not only did they not remove asbestos, they were not qualified to remove it. But that's separate from what they were appointed to do. They were appointed
Yes.
to do both.
Yeah.
Yeah.
Chair, this particular letter, why it went to Treasury, right? Because normally if you are uncertain about a particular thing, that's what we will normally do. I don't have to ask Treasury, but sometimes you do so just to get certain assurance. Now, I think perhaps this was a copy. There might have been a copy. There might have been another letter where the head of Treasury, I think he wrote notes on the same letter and returned it to me. I think the commission has it, that letter where he simply said, you are allowed, but ensure that the processes are followed. I mean, that's basically what it was. And which letter then I gave to supply chain to indicate that, my idea of writing the idea of writing Treasury actually came from me, to say, okay, let's hear what Treasury has got to say about this particular thing. And that was the only response. Ensure that the processes are followed. I did not have to do that, but I felt it was necessary for me to do that, which is the letter that I gave with those notes to
Supply chain.
Yes, the letter that...
it's the same letter, I think.
I think you may be referring to page 184, just page back one page. You'll see there the same letter, but it has a handwritten note, apparently from Treasury, which says the accounting officer has the power to approve such an arrangement, provided the supply chain management processes have been duly followed and legislation has been complied with.
Correct. It's the same
So
letter.
far from examining the situation, Treasury just knocked the ball back into your court.
Well, once again, and Treasury has got a unit that is, I would call it, that unit is a consulting unit per se, to advise all the departments about various other issues. And supply chain practitioners, all of them throughout the province, all the departments, from time to time they consult and that's what I expected, that there will be a further consultation to do exactly that.
To be fair to you, Mr. Mokhesi, you raise the issue, you ask for advice, and you get a scribbled note in return. That's not good enough, surely, for Treasury, who is in a position to advise and should know, not to at least enter the fray with some advice at least. All they say to you is, you can do it, just make sure you follow the law. I mean, that begs the question, you're asking them, what is the law?
Yes, and documents were sent to them as well.
Yes. I would have thought that after you read that note from them, which says, in part, which says in effect that you can do what you were proposing to do, provided, that's what they say, provided that the accounting officer has satisfied himself or herself that the SCM processes were duly followed and they comply with legislation. I would have thought that with that kind of warning, to say, just remember, you must be satisfied as the accounting officer, that you would have said to your supply chain management team, you see this note from Treasury, you must give me a memo that specifies exactly what the law says we should do, and you must tell me how we have complied. Do you think I'm expecting too much from?
Not really, Chairperson. When this response came, also taking into consideration that I had at all material times had a discussion with the head of supply chain,
yeah.
Also with this particular letter. As you can see,
yes.
The letter was offered by him after I had indicated that, say, well, I know that we are not supposed to consult Treasury here, we have to do it, but let's, just for completeness, let's hear what they say around this particular, send whatever documents, all the documents that are there and so on, let them, and this is what we received as a response, and simply said, okay, this is a response, just ensure that we, the process is above board, basic.
Okay.
And that's basically what.
Mr. Pretorius?
On page 188 of FS8, Ms. Mokhesi, is the so-called appointment letter dated 1 October 2014. It's addressed it's addressed by you to the Chief Executive Officer, Blackhead Consulting Pty Limited, JV. You see that?
Yes, yes.
The second paragraph reads, the department wishes to advise that your company has been exclusively appointed for the audit and assessment of asbestos handling of hazardous material, removal and disposal of asbestos contaminated rubble, and I'm not sure what those next two words are, with SABS approved materials in the Free State Province. 2 points arise. At this stage, you appoint the JV, the joint venture, and not Blackhead Consulting Pty Limited. And the second is the appointment includes the removal and disposal of asbestos contaminated rubble.
Yes, yes.
May I just suggest that the reason why the JV was only introduced late in the day, expressly, your letters refer to Blackhead Consulting Pty Limited and expressly incorporate in later correspondence the JV, is because had the JV be introduced up front, there would be no question of a transfer of a contract from Gauteng to the Free State.
Agree.
You agree?
Yes.
The service level agreement, which we have dealt with briefly in your evidence, but also in the evidence of other witnesses, appears at page 189, which makes it clear that the agreement between the department and the joint venture as the service provider, that appears in paragraph 1.1, is to carry out a project, and project is defined as the appointment of the service provider, that is the joint venture, to assess, audit houses roofed using asbestos material, handling and disposal of asbestos sheets to an approved designated disposal site. That concept is repeated in paragraph 2 under working relationships. That was the appointment to both identify asbestos and to remove it. Correct?
Yes.
Now, we've dealt with correspondence today, but when you last appeared before the Commission, Mr. Mokhesi, a number of other items of correspondence were dealt with, including correspondence involving Ms. Diedrichs from the Gauteng Department of Human Settlements. You recall that?
Correct.
I just want to summarize, if I may, the confusion or the deliberate concealment of facts and how they played out in this correspondence. The first point is that in correspondence that you've referred to in your last appearance, you sought the extension of the national panel contract and Mr. Zulu cooperated. That was in correspondence to National Department. You recall
Yes,
that?
correct.
Later on, you sought to extend the Gauteng contract. You
Correct.
recall that?
Yes.
Ms. Diedrichs sought to extend a panel, not an individual appointment. You recall that?
Yeah, I think I recall that, yes.
Ms. Diedrichs and Mr. Zulu, at least up to a point, yourself, talked about Blackhead. The appointment letter appoints the joint venture. Correct?
Yes.
You've dealt with that.
Yes, we've done it.
And we know that this is not a panel appointment, it's the sole appointment of a joint venture, not Blackhead, not a panel arrangement. And we also know that it's not in accordance with the Gauteng terms and conditions, especially price.
Yes.
Need to deal with another topic that appears in correspondence. Would you go to page 190, please? I've just referred you to the service level agreement entered into between the department on the one hand and the joint venture on the other. The SLA refers to removal, well, identification and removal and disposal. We know that.
Yes.
I think at some stage you called your legal department to account for not making it clear what the appointment actually should have been for. Correct?
Yes.
That appears in the transcript of your interview at bundle FS 6442 to 443. Your legal department drafted this. Correct?
Yes. Yes.
Do you need some file? I think if you need some file, Mr. Mokhesi, they can assist you. I think he wants to look at something.
All right.
No,
if you
I
want to
thought you
see
said
it,
FS.
you want to see it.
Oh, okay. No, if
I mean,
I
it's
thought you were
common
referring
cause. I
me to-
think you accept that you told your legal department
Okay.
to draft,
All right.
and this is what they gave you.
Okay. Okay.
Perhaps it should have just restricted the appointment to what they were actually appointed to do, and that is to identify the asbestos houses.
Yes. Okay.
But what is important is what follows. At FS8, page 234, appears the contents of a letter that begins at page 232, and I'd like to draw your attention to the contents of 234.
232 or 234?
Yeah, do you have, well, perhaps just go to page 232.
Is that 332?
232, Chair.
232.
Yes, of FSA.
Okay.
Now we know, Mr. Mokhesi, that Mr. Zulu played a role in the finalization of the contractual arrangements, and in particular on the making available of funds to allow it to happen. We know that. That evidence has been given.
Yes.
By yourself especially.
Yes.
In order for the funds to be made available, they had to be transferred from the budget of another province to the Free State.
Not in that manner.
How did it have to happen?
Every year, right, after a couple of months, there is an opportunity, or you are given an opportunity to revise your business plan, particularly specific in respect of specific. Specifically in respect of projects, because we run a multitude of projects at the same time, and then you always have this specific or projects that will not make it in terms of the expenditure throughout the year. So normally you are allowed to revise your business plan, and that's how it happened. It's about the revision of the business plan, reprioritizing and indicating what is ready and what can be performed at a particular point in time. So ordinarily the DG will then approve that reprioritization.
But where would the money come from?
Within the very same budget. That you can have sometime a budget, for example, which is not performing for a variety of reasons. It could be for a variety of reasons that the project is not performing. Procurement issues, and sometimes that particular project is stopped because we operate within communities. And that might be problems. Sometimes this actual problem might also be relating to just incapacity of some of the contractors to simply perform.
Or it might be temporarily stopped because of legal challenges.
It might be yes, correct. You know, it could be a variety of factors. So there's always, particularly within the sector, there's always that particular problem where we have every year where you have to revisit the business.
So you
plan.
would have a business plan which would involve the allocation of funds to various projects. A revised business plan would allow the movement of funds allocated
from A to B,
from one project to another.
correct,
Or from one province to
another, correct. That's also an option.
All right. So let's not spend too much time on that issue. We know, to put it at its lowest, that in order for money to be made available for the asbestos project, it would have to be taken from somewhere else, another project or another province.
Yes.
And in order for that to happen, the Director General would have to see a revised business plan.
Correct.
And he would have to be persuaded that it was in order to do so.
He will have to approve it.
And this letter at 232 of FS8 is the motivation addressed to Mr. Zulu of the National Department by yourself on the 27th of November 2014.
Yes.
Now that is obviously after the appointment, but that's another issue. The appointment took place on the 1st of October. This motivation for a revised business plan was the 27th of November. Correct?
Yes.
Now, what Mr. Zulu was told, remember, this is a letter intended to persuade Mr. Zulu to make...
All right, the Commission hearing Free State Asbestos Project-related evidence today. Nthimotse Mokhesi currently giving evidence there. The Commission is also set to hear R1 billion housing Free State Project-related evidence from the former advisor to MEC Zwane, the then MEC at Corporate Governance and Human Settlements, Free State Provincial Government. And you heard the Deputy Chief Justice, the chair of the Commission, saying with regards to accountability, one of the biggest takeaways there was that he hopes that people who come to the Commission will, admit that things went wrong and stop pushing the blame on others, because he says that if you do that, if people don't take responsibility, then they can't contribute to solutions. Then Mr. Mokhesi saying that there are certain things he could have done and he did not do, and he accepts that. And he went on to say he never denied that which had happened was irregular. So that's some of the bigger takeaways. We'll keep a close eye on this commission and get you some of the headlines in the next hour. Let's take a look at
just 3 bullets read: transport of the asbestos to a registered disposal site, disposal cost of the asbestos, all relevant paperwork pertaining to health and safety regulation. Now, this is an inference that can be drawn in submissions, but that list of tasks looks remarkably like what the Gauteng project put up, but I'm not going to go down that route for the moment. All I want to point out to you is that Mr. Zulu was told when he had to consider making funds available that the 850 rand per house would include the transport of asbestos to a registered disposal site and the disposal cost of the asbestos. Correct?
Yes.
Which was wrong. Incorrect. It didn't.
Yes, I agree, what is missing here in this letter, because it's actually impossible to do that at 850 per unit.
It is impossible.
Sorry, it's not possible to do all that at 850 per unit. So what should have the letter should have included? It should have included, which is also part that takes care of because if you remove, you must also replace. The 32, I think, which was mentioned in the proposal, the 32, which was the phase 2 part of it, because 850 per unit is just not possible. It actually was meant to refer to the phase 1 of actually taking stock of what is there. That was basically. I consider what should have been included there should have been that one.
Mr. Mokhesi, that's very strange to me. To say now that the price that you specified as a department in the letter of appointment for a job that consisted of 2 tasks to be done
Yes.
was actually not the correct price. And I guess, there are a number of, letters. I think that the price would also have been in the service level agreement, I would imagine, or not. I haven't checked now.
It will be on the IPW.
Yes, but in the
instruction to perform
in
work.
the service
That's
level
where-
agreement.
That's what gives effect for the work to be done.
Okay, but how do you say in correspondence as a department the price for doing A and B is 850 per house when actually 850 per house is the price for A only? How does that happen? I mean, if you can do that, it seems to me you are capable of actually saying, of taking the price for the two tasks and give it to the service provider for one of the two tasks. In other words, if the first task of identifying and assessing was 850 per house, and the second task of removal, let us assume for argument's sake that it was also 850 per house, which means 1.7 per house. That is the whole job. Okay, so it means
I didn't get that.
Okay, I'm saying, let us say for argument's sake, you know that the first task that you gave to this the joint venture was to quantify, audit, and assess the number of houses roofed with asbestos sheets.
Yes.
That's the first task.
Yes.
The second one is remove and dispose asbestos to an approved and accredited disposal site. Now, what you have just told me is that the price of $850 per house was only for quantifying, auditing, and assessing the number of houses roofed with asbestos sheets. It did not include to remove and dispose asbestos to an approved and accredited disposal site. All right?
Okay.
Now, I'm saying that I find that quite strange, because it means that if you can say 850 is the price for both when it's actually the price for one, it means you could actually take the price for both, let us say here for argument's sake, 1.7 per house, and say it's for one of the two tasks. It just seems to be gross negligence, to say the least. You understand what I mean? How does such a mistake happen? And to make it worse, the service provider doesn't point out that, no, Mr. Department, you got it wrong. 850 is only for the first task. It doesn't include the second task. So everybody, in terms of paper, accepts that 850 per house is for both tasks. But you are saying, no, actually it was for the first task.
The original proposition or proposal define it in that particular manner. In fact, the original proposal was saying I think it was saying 1.7, if I'm just speaking 1.7, but it was reduced to 850. That involved assessment, audit assessment, and so on. In Gauteng, we know that it was 650, and that was also the first part of the problem in terms of the why this contract was done. And the second part of the proposal indicate the 32, which will involve all these other issues. Now, at 32, I think 32,000 per unit, which will also involve, because if you remove, you also have to replace. So it will not have been possible for 850. I hear what you're saying, Chair, in terms of material omission from what the proposal was originally. However, this would have been, if for example, everything there was no problem in terms of the appointment and so on, and we would have continued into the second phase, this would have been corrected.
Mr. Pretorius?
Let's move on to another topic, if we may, Mr. Mokhesi. We know that in this particular series of transactions, the contract with the joint venture for the identification of houses and perhaps certain other work too, I'll come to that in a moment, was in the region of 250 million rand.
Just raise your voice, Mr. Pretorius, please.
We know that the agreement between the department and the joint venture agreed to pay the joint venture an amount of over 250 million rand. Correct?
Correct.
We know that there was a subcontract and an appointment of Blackhead for an amount in the region of 54 million rand to do most, if not all, the work. We know that, correct?
Yeah, which originally okay. I know of it now.
Yes, you
Okay.
know of it now. So I'm
please.
not saying you knew of it then. In fact, that's precisely the point I want to raise. And perhaps you can assist the Commission in this regard with your experience and knowledge. We know that there was a further subcontract for most, if not all, of the work to be done for 21 million rand to the Ori Group. We know that. Correct?
My response will be the same as what I've said
Yes,
previously.
no, I
okay.
understand
Yes.
that.
Yes.
It can hardly be alleged, therefore, that there was value for money in the payment of 250 million rand. Would you accept that?
Mr. Pretorius, can I? Okay. Sorry, Chair. Can we? Well, I don't know whether should I say agree as false, and also, you know, taking the about what has happened around this issue of value for money. You know, and I earlier indicated that there was this court decisions that says there was no overpayment. I thought the commission had that, you know, but I was just informed that they don't, but we'll make that available.
We would like
Right.
to see that. If we
Right?
What did you say that decision said? I'm
A
sorry.
political party took the
department.
department to court,
Yeah.
and they, you know, and the decision, one of the decisions or one of the findings that was made was that there was no overpayment. Okay, it's in the court judgment, but it is not on the merits. Let me indicate that it's not on the in other words, it's not on whether the contract is irregular or not. That's beside the point. I think with that. And one of how we said value for money, we relied on what the judge said at that particular, in terms of that. Okay. That was that. The second part was also part of internally, you know, how do we deal with irregular expenditure when it has occurred? You know, there's a process of a framework in terms of how do we deal with that. We also dealt with that. And I'm certain the AG will not have agreed in terms of the write-off if maybe it is because none of the parties involved there were experts. Maybe it is because of that. Yeah, I'm just saying. But there was a process. That's the second part. And subsequently, there was also an investigation by the public protector, who arrived at a different conclusion. I think the commission and the public protector's conclusion are the same. We now have an investigation by the SIU. Now, all that I'm saying, because also the SIU will also come up with to say, let's leave, in terms of the issues of the value for money, can we then leave it perhaps also either to the SIU?
No, we can't.
To
No, Mr. Mokhesi, we can't. We have to make our own decisions. We're not going to,
okay, can I leave
to
that?
let somebody else make decisions
Okay.
on this, yeah.
Because
even if a judge had said there was no overpayment. Just from that.
Yes.
I haven't read the judgment. I don't know what the judgment says, but it seems to me that he or she might be talking about whether you paid more than you had undertaken to pay, which is different from the question that Mr. Pretorius is asking, namely, when you have regard to A, B, C, D, are you able as HOD at the time to say the department got value for money? So you go into what do you mean when you say value for money? You look at what happened and you say, yes, we are able to say we got value for money, or you say, look, knowing what we know now, we are not able to say we got value for money.
It's a tricky question for me because, you know, there's no what would I say? There's no conclusion, because we might at a later stage, the department might have to write back based on, you know, based on the either the outcome of this of the commission or whatever body that has been tasked to investigate this issue of value for money. So but we might have to write something back and also pursue.
But that worries me even more, Mr. Mokhesi. I take it that one of your obligations, your responsibilities as HOD at the time was to see to it that whatever contracts your department entered into with any service provider was such that the department would get value for money, and that when that service provider had finished doing the work, you had an obligation to apply your mind to the question, in regard to this contract, did the department get value for money? And if the answer you get from that is no, the department did not get value for money, you would be worried and you would need to act on that.
Yeah, Chair.
Now, the answer you are giving me suggests to me, and maybe I misread what you are saying, that you didn't do that, because if you had done that, you'd be ready to deal with the question that Mr. Pretorius puts to you. You
Chair,
say, I don't know what the SIU will decide, I don't know what this commission will decide, but I have applied my mind to the question as HOD, and my answer is A, B, C, D.
Chair, at that time, right, this information that Mr. Pretorius is talking about, that they were subcontracting and so on and so on, that information was not there. At that particular point in time, the fact that it was written off, it is because there was certain work that was done, and they came to a conclusion that there was value for money, right? That was before the other inquiries, like the inquiry right now that is happening, which attempts to get deeper into the issues. Now, obviously, when that comes, that's why I'm mentioning this independent, which I would say independent body outside the department, right, will then be in the position to inform, because I'm sure the service provider themselves will also want to make a point or a case in terms of whether value for money. The outcome of this commission in terms of that is going to be very important as well, because then it's done independently. Outcome of the commission plus the outcome of an independent institution like SIU, and I'm sure somewhere we will converge, and there will be indications as to why there's either no value for money, because I have done that already, and what is being done now seems to contradict that conclusion based on the information that was available then.
Mr. Pretorius.
Do you wish to take the short adjournment now? I'm happy to do that.
We can either take the adjournment, or if you want to pursue one or two questions before we do so, I'm happy to.
Well, perhaps we should just tie up this topic. Mr. Mokhesi, we don't know what the court was told in relation to this contract and its performance. We've asked for the judgment, and perhaps we will still get it.
I think at the initial investigation that was given to the investigators, but we'll make that available.
Yes, but the point is we don't know what the court was told and what conclusion it drew in relation to the facts that we now know before us. So I'm not sure we can rely on the court as a fair and informed judge of whether there was value for money.
Well, I'm not saying that, Mr. Pretorius, you should, because even that judgment was never appealed against. Okay, and so in the absence of anything to the contrary, one is bound to conclude as I've concluded.
I'm putting the contrary to you, Mr. Mokhesi. We don't know what information the court was given in regard to value for money, nor do we know now what it found. As the chair has pointed out, it's for this instance to make its own findings on the facts before it.
Yes.
You now know the facts, and we now are dealing with hindsight, not what you knew at the time. I am quite willing to approach this matter with the benefit of hindsight for the present purposes. It appears, and I want to get to another point, because the chair will make up his mind as to whether there was value for money. There's plenty of evidence, including the evidence found by the public protector that the work was done for approximately 21 million rand, right? And 250 million rand was the charge for the work. And quite frankly, it's quite obvious that there was no value for money here. I want to raise another point with you, Mr. Mokhesi. And that is, what happened here, unbeknown on your version, and we must accept that for the moment, unbeknown to the department, there were two levels of subcontracts happening. Correct. First to Blackhead for 54 million rand, then to Ori for 21 million rand to do the field work. Correct.
Yes.
You weren't told that.
No. I think you said Blackhead, Mr.
No, yes, I was not told that.
Master Trade,
Master Trade, sorry, Master Trade. First to Master Trade and then to Ori, correct? You weren't told about these subcontracting arrangements. With hindsight, how would you regulate matters to prevent this sort of thing happening again? So what we have here, and it's not uncommon, according to the investigations of this commission, is that you get a company that tenders for government work and then subcontracts it at a much lower price and makes a huge profit, simply for intervening as the contracting party. Can this be prevented? Can prejudice to the state be prevented? Can you help the chair in that?
In terms of making suggestions,
yes,
or how...
you were on the ground, you know, you have experience. Perhaps you can help the chair.
Yeah, Chair, sometimes the contractors are also becoming very creative. It's very difficult, but ordinarily there would be a particularly on construction, because people do sell work. We know that it does happen, like Mr. Pretorius has indicated. In terms of trying to maybe prevent or try to manage, because you cannot completely, I don't believe there's anything that says you can completely, but you can minimize opportunities for that happening, is to have with the main contractor about how much, in other words, putting up the rules to say, yes, you can subcontract because because there will be work that needs to be subcontracted in any contract, in any event. Setting out the guidelines to say you can only subcontract no more than 20 or 30% of the work. The rest, it must be done by yourself as the main contractor, and get perhaps the list of the people who will be doing the work, and prove that they are the actual people, they are the actual your actual employees, so to speak. So in requesting those particular details, perhaps maybe for the future, it could assist to prevent people subcontracting or selling work 100% to others.
Yes, just one point. It seems that from the side of the various departments that give work, we've heard both in this matter and in the housing matter of very creative ways of avoiding competitive bidding. And it appears that greater control must be exercised and loopholes must be closed.
Got it.
Do you agree?
Yes, I agree.
There's just one more brief topic to deal with, Chair. May we take the short adjournment?
Well, before we take the adjournment, I am interested in hearing what you have to say, Mr. Mokhesi, to Mr. Pretoria's proposition that on what we know now, the department did not get value for money. He mentioned to you some of the things. You have told me what you thought then, some time ago. Are you able to say whether, with what you know now, you still stay with your view that the department got value for money? Or are you saying, with what you know now, you no longer, you think the department did not get value for money?
Okay, Chair. On the face of it, without saying how much that value is, because it's still got to be determined. There will be to say the department probably did not get full value for money, without putting an amount. And this amount, I think, will be the outcome of the inquiry at the stage to say this is what we think. And then, obviously, as I've indicated now, the department, based on that evidence, will then have to write back as that which is deemed not to have been value for money and try and recover it. I think that will be the normal process going forward.
Is your answer that your view is that the department did get some value, but you are not able to say it got full value for the 250 or so million rand that it paid?
Yeah, taking also into consideration that we did not pay the full amount, particularly when the public protector started the investigation. Also as a way of managing the risk, because we could not predict what the outcome of the public protector would be at that particular time. So, and I think the same information that the public protector had in her investigation is similar to what the commission, and possibly the commission did more, basically. Now, based on that, and with possibly the quantum that I'm sure the commission will be able to determine, whatever remain, what will have to be written back. But my answer is possibly the department did not get full value for money. In this sense, I'm not able to say how much.
Yes, okay, all right. Let's
Chair.
take the...
Chair.
Oh, yes, Mr. Mpofu.
Thank you, Chair. Just a request more for personal reasons.
Yes.
If Mr. Pretorius has indicated to me informally that he needs another 10 minutes or so. So I wanted to request, if it's at all possible, whether we could deal with that and then take the break, or...
Yes. Yes, no, we can. We can do that. Yeah.
Thank you.
Okay, let's do that. But
Thank you very much.
yeah, maybe before we do that, let me ask another question that I was going to ask after the tea adjournment. You might not need to go to this page, Mr. Mokhesi, but it's page 234. That's one of the pages of the letter that Mr. Pretoria...
Expenditure. So currently we have taken another matter to court to compel information from government.
Yeah, okay. Somewhere in the middle of the page, you say the objective of the project is twofold. Then you specify the two objectives. I'm not going to repeat them. Then later on, down the line, you say all asbestos will be removed and disposed of as laid out in the Occupational Health and Safety Act and the Regulations 85 of 1993. I take it that that's the Act and the regulations that also specify the requirements or qualifications that need to be met by anybody who wants to remove asbestos. Is that correct?
Correct.
Now, Mr. Sodi gave evidence here, and he conceded that Blackhead and the joint venture did not have the qualifications and were not accredited to remove asbestos. Did you hear that part of his evidence?
Yes, I've noted that.
You have noted
that evidence that he gave.
Yes. Now, were you aware of that prior to him giving that evidence, or were you not aware?
No, I was not aware that they don't have
the qualifications.
Yes, I assumed basically that they should have, because they did the work in Gauteng. But as I've indicated earlier, Chairperson, the documents, if we had requested the documents of all Gauteng in terms of what this matter would have been picked up as early as that particular time.
Yes, but you see, I'm worried because from the fact that you say in this letter, all asbestos will be removed and disposed of as laid out in the Occupational Health and Safety Act and the regulations, gives me the impression that you are aware that there is a special procedure that must be followed, is laid out in that act. And I take it that you would also have been aware that not anybody could do this job. This job requires somebody to have certain qualifications or to be accredited. You were aware of that, were you not?
Yeah, yes.
Yes.
And this, okay.
Yes.
Sure.
So you see, my question, therefore, is how was it possible that as HOD, you could not at least say to your officials, where are the qualifications or where is the accreditation of this entity that they can do this job? Because that must be quite an important and basic question to ask before you give anybody a job.
Let me respond to that.
Yes.
It's not the first time that we remove asbestos. It was only, this scale is it was a different one. We have been, particularly with old pre-1994 houses which are dilapidated and so on. Now, we have been removing them, albeit not on a, on a larger scale and so on, only to people to those individuals who are qualifying for government assistance and are living in those houses. Now, it's not a new thing, the issue of the removal of asbestos. I don't have to repeat it to the officials. So they know that. As I've indicated, this was not the first time, Chairperson. We have done that partly in Soutpan, even in Mangau, in certain houses where, and ordinarily what will normally happen in that instances, while we appoint a contractor to do that, he would have outsourced, because that's not the main part of it. He would have requested somebody, because there's quite a few people in the province who are qualified to remove that, the asbestos. He will then do that before the demolition of a structure. So that we have been doing even before that.
But are you saying to me that you were, okay, you said earlier on it was the first time you had that they Blackhead did not have accreditation or qualifications. So you were under the impression that they did have the necessary qualifications or accreditation, is that correct, or
yes,
not really?
Yes.
You were under that impression?
Yes.
But that's something you had not checked. You assumed that they did.
Yes, because in the normal, in our normal course of work, we have always, some of us have indicated, remove asbestos, and there are procedures. The first one is you must produce the certificate that the person who's going to remove that is there's a process as to who qualifies and so on. The disposal sites, it's not anywhere. You can't just dispose it, for example, in any landfill site and so on. So we have been doing that before.
But when you were doing it before, did you ask to be satisfied that the person who would do the removal would be qualified? Did you ask for the qualifications to be placed before you to know that, it could be done?
Okay, let me put it this way. It's not before me, but before the officials, because it's not the first time. They are there, the removal of asbestos, as I've indicated. We have been doing it as a matter of course, particularly for the beneficiaries who are qualifying to do that. But who are qualifying for government assistance.
But why is there nothing that is given to you that says, if we give this job to this entity or this person, it's in order, because in terms of legislation, a person who does this job must have the following qualifications or accreditations, and this one has got those accreditations or qualifications, and if necessary, here are copies or whatever. Maybe they don't say that, but at least they say it is there. We know it, but I would have thought that they would attach to whatever documentation they give to the HOD to satisfy him or her that this person meets the legal requirements to do this job. Now, in this case, the officials don't give you anything to indicate that you are appointing somebody who meets the legal requirements to do this job. I would have thought that it's quite basic to say, if you want me to appoint anybody, I must at least know that they qualify in terms of the law to do this job? Because I can't appoint somebody who might turn out later not to actually have the qualifications.
Chair, certain things are so basic, like you have just said now, you know, are so basic that I don't even, as an accounting officer, have to say it, because this is the work that we have been doing. You know, in government, things are largely standardized, right? To say if this is what you have to do. There is a checklist of the individual. So, and I think you I've earlier indicated, you know, with a span of control of 11 people that reports to me. It's actually, and each one of them being senior managers in their own right and could be actually be accounting officers in their own right. They can apply for my job, right? And then they are running their own respective units. Right. So in most of the cases, it's through engagement and reports and so on. So that is in a checklist, basically. And
you expect them to do that?
I expect that. You know, I don't have to even to tell them, because it's not even the first time that we're dealing with asbestos.
Well, now that we know, or let me ask this question. If you knew that Blackhead or this joint venture did not have the qualifications or the accreditation required to do the removal of asbestos, would you still have appointed them to do this job?
No.
You would not have appointed
they
them.
don't qualify. They will not have. I think we'll probably be only in the position to pick up this at the second phase, because then they will have to produce, because now other parties will be involved. Department of Labor, for example, in this whole process, because of the sheer magnitude of the work. And definitely labor would have been involved, and you know, there would have been checks and balances along the way. Even before they start, they'll have to produce that.
So it seems to me that the joint venture of Blackhead also made a misrepresentation to the department, because in this service level agreement, they assured the department that they had the capacity and the experience, I think they say the qualifications, if I'm not mistaken, to do the job. And the job as specified included the removal of asbestos, which they had no accreditation to do. Is that right?
Yes.
Is that your understanding as well?
Yes, that's my understanding. They were not accredited to do the job.
Yes.
Now that we know.
And there may be a risk, I would imagine, but you might have a different view. There might be a risk that if and when you want to do the actual removal, maybe whoever you appoint might say, well, the first part wasn't done properly, and they need to do it themselves, and then there might be duplication of payments. Or do you think that's not likely to happen? Or you don't?
Well,
know?
that's a risk. Chair, as we have indicated, that's a risk. That could have been a risk. Perhaps when.
Yeah. I'm sorry, Mr. Pretorius. I understood Mr. Mpofu's request to be aimed at us finishing with Mr. Mokhesi before we take the adjournment. He said for personal reasons, but I understood you to still have another topic or something that you wanted to
Yes, there are two
raise.
topics, Chair, and perhaps your guidance on one of them.
Yeah.
10 minutes is perhaps typical of Council's forecast, and I include myself in that. Very optimistic.
Yeah.
Chair. We've still got to deal with one discrete topic. There's a question on arising out of this exchange that I'd like to ask. Then there are the public protector's findings.
Yes.
Now, the public protector's findings are a matter of record. They're there in black and white.
Yeah.
They're not going to change as a
Yeah.
result of anything that happens here today. But it may be a consideration that if you're going to have regard to those findings, it may be fair for Mr. Mokhesi to have a chance to comment on them. And that is the reason why we've extracted certain findings to enable Mr. Mokhesi to comment on them, should he so wish. He doesn't have to comment, but at least he has the opportunity. I'm not sure what your preference is, Chair.
Yes. So on your assessment, if you have got to deal with all of that, how much time do you think you might need?
30 to 40 minutes.
Yes. Mr. Mpofu, what's your situation?
It's okay, Chair. We can take
It's
a
okay.
break.
Okay, let's take the tea adjournment. It's 10 to 12, and then we'll resume at 5 past. Yeah, okay. We adjourn. taxpayers' money that seems to have been paid away with no real work being done. Do you think it would be unfair to expect that your attitude would be that under your watch as head of that department, you would be more stricter in terms of making sure that processes were followed and legislation was followed, because you wouldn't want something similar to happen?
Is the chair saying I should have been more stricter?
No, I'm asking, so maybe let me put it this way. It seems to me that there may be room for saying, given what you found when you were appointed as head of this department, and what I'm talking about is the financial loss incurred by the department in regard to the 1 billion rand housing project under Mr. Mokoena, your predecessor. Given that that is what you found, and it was quite a big problem, I would expect that you would have been more determined to make sure that such losses as far as possible were avoided during your term, and that for that reason you would be stricter in making sure that legislation and processes were complied with during your term. So I'm putting the question, do you think it's unfair to expect that that's the attitude you should have adopted?
Chair, I don't think it's unfair to expect that. And, during that particular time as well, also due consideration should be taken that particularly there was a period where we did not, because of the disciplinary process and so on, and positions that we could not fill. Somehow, even the controls perhaps were not as they should be. And as I've indicated, I've done a lot of introspection around this particular issue. I can't undo what has happened, but I can sincerely do something about going forward to say what happened, people that I trusted, particularly those that I work with, because my attitude has always been that, unless a person, because if you don't trust individuals that you work with, it's also a problem, because you have to, at the position that you are holding, you have to trust individuals and hope, because these other individuals, or this particular individuals, was not part of that which was there. As I've indicated that I've known him before, even before I joined the institutions. I've worked with him elsewhere, and I know his capabilities. And I thought at the time, this is the person, this is the new blood that I needed in the institution because of the expertise. But it has happened, and I can't change it, and I feel terrible about that.
Okay, Mr. Pretorius.
Thank you. Thank you, Chair. Would you please go to bundle FS1, Mr. Mokhesi, at page 59.
Page 59.
Yes, please. Chair, this is the second affidavit of Mr. Mokhesi. To the best of my recollection, it has been admitted as an exhibit, but perhaps just in case.
Page is it?
Page 58 rather, of FS1.
Oh, that's where it ends, or not?
It's exhibit TT 2.2.
No, he gave me FS12 instead of FS1.
Page 60 of FS1, is that your signature, Mr. Mokhesi?
Page 60.
Page 60.
Yes.
And this is your second affidavit to the Commission?
Yes.
It's exhibit TT 2.2, Chair. You go to page 59, paragraph 7.
Yes.
You say in paragraph 7.1, during the time of the asbestos audit, I became acquainted with Mr. Edwin Sodi. We became friends. As a result of my appreciation of Sodi's business skills and my impression that he enjoyed wealth, I resolved to approach Sodi to join me in the investment in a property transaction, referring to the acquisition of the property referred to in paragraph 6. The property referred to in paragraph 6 is a residential property in Bloemfontein, correct?
Correct.
Paragraph 7.2 and the statement in paragraph 7.1, is that correct, true?
Yes.
Paragraph 7.2, Sodi was interested, whereafter the Lekemo Family Trust, represented by myself, concluded a commercial transaction. The terms of the commercial transaction are contained in a written agreement annexed as Annexure D. We'll get there now. Correct.
Yes.
The third statement you make in paragraph 7 says it needs to be recorded that at this juncture, that the asbestos audit, which was conducted by Blackhead Consulting Pty Limited, was already finalized at the time the transaction was entered into. At that stage, certainly the stage the agreement was entered into, payments were still being made to the joint venture. Is that correct?
Correct.
Paragraph 7.4 reads, Sodi, in terms of the provisions of our agreement, caused payment of the amount of 650,000 rand to the trust account of Krama Veeman Joubert attorneys in order to settle Sodi's portion of the purchase consideration in respect of the property investment. Correct?
Correct.
Now, we know that Sodi didn't purchase the property. A trust purchased the property. Correct.
Correct.
And Mr. Sodi himself had no interest in the trust. Correct.
Yes.
So we know that Mr. Sodi had no real right in the property. He didn't own it, whether via a trust or otherwise. Correct.
Correct.
The only obligations and rights that he had appear in the agreement, which we will refer to in a moment. Correct.
Correct.
You say that Sodi was interested, whereafter Lekemo Family Trust, represented by myself, concluded a commercial transaction. Let's look at FS1, page 91, please. Correct me if I'm wrong, or putting the position incorrectly. That is the signature page of the agreement.
Yes.
It's signed by yourself on the 1st of April and by Mr. Sodi on the 1st of April.
Yes.
If one goes to page 89, you will see the first page of the agreement.
Page?
89 of FS1. You see that?
Yes.
It's an agreement between Blackhead Consulting Pty Limited and Lekemo Family Trust, dash IT 444/2015 brackets, capital B, close brackets.
Correct.
That is the registration number of the trust.
Correct.
This agreement was signed, was it in this form, each page is initialed, on the 1st of April 2015, correct?
Yes.
And the
Yes.
registration details of the Lekemo Family Trust are there in typeface, correct?
Yes.
We know from documents that are attached that the trust was indeed registered in 2015, but the trust deed from FS1, page 84, if you would go there, was signed on the 4th of May 2015. You see that?
Yes.
The various trustees sign, and you as the founder trustee sign in Bloemfontein on the 4th of April 2015. This document is the trust deed
I'm sorry, what page did you say we should go to, Mr.? Did you say 84?
84.
84.
84. This is the signature page of the trust deed.
Oh, okay.
The first page is at page 62.
Yes.
So the trust deed was officially created or officially signed and the trust created on the 4th of May 2015, correct?
Yes.
And it is only after that that the trust could have been given a registration number because it didn't exist before 4 May 2015,
Yes.
correct?
Yes.
Or 4 May, yes, 4 May 2015. So when the agreement was signed in April, there was no trust, firstly, and it couldn't have had a registration number because it couldn't have been registered by that date.
Okay.
Can you explain that? It seems to me that
Can I respond to that?
Well, perhaps you should explain before I suggest an explanation.
And please look this side.
Okay. Sorry. In terms of the agreement to form a trust was already there. Indeed, the agreement was concluded on the 1st. The trust was subsequently formed thereafter. Then the trust number was put there later. This is what we in terms of the vehicle that was going to be used around for the acquisition of this property. Indeed, the agreement was that I will form a trust. Although indeed the trust was registered later, and the purchase of the property, of course, also was later. But the agreement had already been reached.
Let's get to whether the agreement of April reflects the correct facts in a moment, but I understand it reasonable to conclude that the trust was created as a vehicle to conduct this transaction.
We already had an agreement, Mr. Pretorius. We already had an agreement, even though the trust was registered later. Because currently the trust, the only asset that the trust holds is this asset.
So my proposition that I'm putting to you seems fair, Mr. Mokhesi, that you decided with Mr. Sodi to create a trust that would own the property.
Yes.
The answer was yes.
Correct.
Is that right? The answer was yes.
Correct.
And so insofar as the agreement was entered into before the trust was created, it records something that could not have been correct. Because at the time the agreement was entered into, no trust existed. Yet the agreement reflects that the trust did exist at the time.
There was no trust at the time, but the agreement was that I will form a trust.
Yes. All right. So we're at least on the same pages, as it were. The way that this arrangement was made, from Mr. Sodi's point of view, he makes a payment to the trust account of an attorney, correct?
Yes.
If one follows the trail, that payment then is allocated to the benefit of the Lekemo Trust, correct?
Yes.
So, and the property is not registered either in your name or in Mr. Sodi's name, correct? Even though it's a joint investment.
Yeah, yes.
Correct. So nowhere in Mr. Sodi's books, as it were, does it appear that he made a payment for your benefit or for the joint investment, let me put it neutrally. Nowhere does it appear that he is the owner of a property together with you in any records, correct?
Well, I don't know what appears in Mr. Sodi's.
Well, it doesn't appear, it wouldn't appear in any bank account.
Well, it means there is no document that would reflect that anywhere. He means there is no document anywhere that would reflect that Mr. Sodi owns the property or has rights into the property.
No, he only has a not real right, I think personal right in terms of
Yes, but apart from that agreement, which creates the personal right as opposed to the real right that Mr. Sodi has as investor in a property, and that's another issue that maybe Mr. Sodi can explain. There is no official record. In other words, there's nothing in the deeds office that shows that Mr. Sodi owns a property with you. There's nothing in any bank account that shows a payment to you. Correct? All that exists is a payment to an attorney's trust account. That's in Mr. Sodi's records, presumably. And it doesn't show his interest in a property together with you. There's no document that would show that except the agreement privately entered into between you and he.
In respect of the property.
Yes.
That's the agreement, yes.
Yes. As far as you're concerned, there is no record in your bank accounts of money being received from Mr. Sodi. Correct.
No, it couldn't be, it couldn't, the record that exists is the record in the attorneys.
Yes.
Right. Plus, there is a trick about that. Plus, that for the acquisition of the property, in which instance I have, on my side, I have raised 60% of the required through a bond, and him 40% of it.
Please move this side. Just repeat
Chair.
that answer. I don't hear.
I'm saying, the record that is available is the record, is what goes to the transferring or the transferring attorney, and plus the purchase later stage on the deeds, on the title deed, which indicates the full amount plus what I've raised, the 60% of the required capital, and 40% of the full amount is reflected.
But Mr. Pretoria's proposition or question
Yes.
is that even in your bank accounts, there would be nothing that would show that Mr. Sodi put in this amount for this joint venture between the two of you concerning this property.
It can't be
Is
on
that
my
correct? Is that not correct?
Okay. Yes, but it can't be on my bank account if our agreement was for investment in property. It could not be in my bank account.
Well, whether it could not be or was not, the fact that nothing appeared in your own bank accounts in relation to any money given to you by Mr. Sodi.
This money is not given to me, it's for investment purposes. Right? Maybe let me try and indicate that the property that is in Bloemfontein, that's not my primary it's not my primary residential property. I'm staying in that property because I work in Bloemfontein. That's the only reason why I had to do it. And I also stay there I also stay there. If you're going to stay in a place for more than 3 years, the rule of thumb is instead of renting, you must buy. And I have stayed, indeed, for the past 3 years or so before this, I had already changed. I had rented and moved twice from different places simply because the landlords were selling at that particular, and I could not get the 100% bond from the bank. Why I could not get the 100%? The ABSA picked up that I had a judgment against me, which was obtained by SARS, and therefore my credit rating could not be in the position to offer me to be able to raise the 100% bonding. I must also indicate that before I get to know that Mr. Sodi is investing in properties, I had also approached family members who are also, albeit in a small way, who are also involved in property investment, but they could not come to me. They were not in the position to support me in that because of the commitment at that particular time. So This was not, this was not money for me, because it has got to go back to Saudi as an investor. First, the guaranteed capital, plus whatever surplus or profit on a 60-40 profit sharing.
But it seems from what you have just said that you needed accommodation in Bloemfontein. Is that right?
Correct.
And you had challenges in getting a full bond because of the SARS judgment. Is that right?
Correct. Which I was not aware of.
Sorry?
I'm saying which I was not aware of.
Until ABSA raised it.
Until ABSA raised it.
Yes. You then approached Mr. Sodi, is that right?
Correct. Because I learned that he also invests in property. He has various investment in property.
Yes. And then the two of you had a discussion about investing in some property.
Yes.
And from what I see, it looks like you were not talking about properties. You were talking about just one property.
Just
is that right?
Specific,
That specific property.
That specific property.
Had you identified the property by the time the two of you spoke?
No, we have not.
You had
normally,
not.
yeah. Let me try and explain this process, Chair. You see, because when we get into that type of entrance, it can't just be any property. It's got to be a property that can demonstrate the appreciation in value, because issues like location and so on becomes important, right? Now, with all those particular issues, you will normally say to the estate agent, this is what I'm looking for, right? And it must also be a secure property, because that is not my primary residence. And I must not be worried when I'm away for an extended longer period that, what is happening there and so on. So, and the area as well becomes key, becomes very important as well. Now, you give the estate agent to say, right, this is what I'm looking for, and indeed he goes out and he identifies a property to say, this is the property that I think, which indeed is the property that is secure. It's in an area. In fact, it is a new area in Bloemfontein over a period of from 2013 to up to now. On a trend, it has been, the prices have been growing there at 16%, at 11%. That information is widely available. Had been going there at 11% per annum, right? Now, and obviously, if you have to ask somebody to invest, if I were to ask you to say, please invest with me in this particular problem, the question is, why should I invest with you when I can take my money, for example, and put it elsewhere in the bank, where there's a risk-free, you'll sleep very well. You won't have to worry, and then you will get your period. You must demonstrate that you are going to get a return on investment that is more than what you would get if you were to put in a risk-free investment. Now, what is the risk-free investment that is available around? Not even the bank. The absolute risk-free investment that you can compare it with is a treasury bond investment, which form the basis that says that if I take this money for a period of investment of 7 years and put it in a treasury bond, how much will I get in terms of the future value of that investment? Obviously, the treasury bonds have got different maturity periods. Okay, I'm just trying to give the thought, what the thought behind this particular issue.
Yeah.
Now, okay, now, the treasury bond that matches the maturity period of this investment is R197, which a coupon rate, which is 5.5 CPI, coupon rate of 5.5%, because it's the safest investment that is risk-free, that is available, that will match the investment period or the maturity period of that, which is 7 years. Okay, it was issued in 2001, but the maturity period of it is December 2023, which nicely match the 7 years of that investment. Now, what I have done on in terms of the return of investment for the portion of he will come out better than when he puts that money in the risk-free investment of 5.5. So the sums that I've worked out, if he puts that for that particular 7 period, it works out roughly around 950,000. But if he invests in this particular for the 7-year period, he will get first his full capital, 950, plus approximately around about 350,000, which works out to 1.1 million that he will get from his investment. How does that happen? For example, now the bond that I've taken on the 1 million. In fact, all the risks that relates to the properties are with me, okay, and not with him. That first that I mentioned, your property rates, property insurance, suretyship, and so on, they are with me. Now, how does that happen? The loan period of the 1 million bond that I've taken, it's over a period of 20 years. The installment on that it's roughly around 7,800. The interest is 6.80. This is the contract that I've signed with the bank. Now, I'm not paying 7,600. I'm actually paying 13,000 of that particular bond. Why? To reduce the repayment period, and by so doing, I've halved the repayment period instead of 20 years to 10 years. Now, the balance of the capital as at the end of, in period 7, in 7 years, will be roughly around about 300,000 in the manner that I've been paying consistently more. I think you will also appreciate and know that if you pay more on a bond, you tend to reduce the period very quickly because bond payments, interest on that are, the bond it's on a daily basis. Interest is charged on an outstanding balance on a daily basis. It therefore pays to pay a little bit more, which then says at the time when we will be selling the property, because right now the properties in that particular area, the last sales from September or from August up to September, for example, the lowest was at 1.8 and the highest was 2.6. Now, if I were to sell this particular property now, I will easily sell it for 2 million. However, I can't do that at this party because the only person who will benefit currently out of if I were to sell it now, it will be the other party and not myself. Taking into consideration that currently all the costs that relates to that properties are with me. So at the end of I will have to wait for 7 years to be to sell so that it could be for mutual benefit of both of us. Because currently, the favor is on his side, given the risk that I've taken.
But the idea between the two of you of investment in property was limited to this property. Subsequent to this transaction, the two of you did not get involved in any other properties together, or did you?
Well, he himself has got investment in other properties as
yes,
well,
but the two of you?
It was only limited to this particular.
Only this property?
Only limited to this particular property.
Yes. Mr. Pretorius?
As I understand from your answer, two facts at least emerged. The first is that you could not raise a bond beyond R1 million, correct?
I could not.
The second is that you intended to live in the house and did live in the house.
Yes.
So in order to obtain a house worth 1.6 million rand in a secure estate with all the attributes you've spoken of, you needed assistance, correct?
Correct.
And you have been able, with your limited ability to raise bond finance, or the limited ability to raise bond finance, to live in that house since 2015, correct?
Correct.
Would you say that at the very least, after 7 years, as you say it on your calculations, this arrangement between you and Mr. Sodi would have been mutually beneficial?
At this stage, if, as I've indicated, it is mutually beneficial, okay, in terms of the period. Because understand that all what I'll perhaps maybe refer as landlord expenses, so to speak, are with me.
Sorry, yes, have you finished?
Okay.
I didn't want to interrupt you. I'm sorry. If you hadn't finished, please.
No. The point that I'm trying to make, Mr. Pretorius, is, you know, the amount of all the expenses, your maintenance, property taxes, insurance, and over and above that, I've also indicated that I'm paying more to reduce the repayment period, and possibly at the end of 10 years, because in these instances, the plan is after 7 years, either two things will happen, right? I will refinance the property further or simply sell it outright. Okay? I understand. And make the calculations in terms of what should have been. Okay? But that's a decision that one will have to make at that particular. But his original investment is guaranteed.
Well, that's the point we'll come to in a moment. Can you explain why Mr. Sodi, who wants to invest in property, would not register a share of that property in his name, but limit his rights to rights against a family trust? Can you explain why he would do that? Ordinarily, an investor in property would want rights in that property, I would understand, but in this case, all he does is enter into an agreement with a trust, and presumably any collapse of this whole scheme would leave him with rights against a trust only.
Well, how would it so collapse in these instances? Because it is what it is, Mr. President. I don't to say why would he do that?
Because something could happen to you. You could go insolvent. You could fall ill. God forbid, you could.
Yeah, so
pass
much
on.
the reason.
No,
So
no,
much.
Sorry. Let
Okay.
me finish.
All right. Sorry.
For one or other reason, you could stop payments. That property could be attached by the bank. All that Mr. Sodi would have would be rights against a family trust, which might at that stage just be an empty shell. He doesn't have the security of his investment in the property. That's strange.
Okay. All right. Let's look at what is the value of this particular house and the value of the or the bond itself where it is. Now, what? No, assuming what you're saying.
I'm sorry, Mr.
Oh, sorry.
I'm sorry. I'm going to interrupt you. I think you seek to answer Mr. Pretoria's questions on the basis of what the value of the house is now. I think his question requires you to cast your mind back to the time that the agreement was made. To say, he's saying to you, Mr. Sodi, one would have expected that Mr. Sodi would insist on having rights in the property itself, rather than having, you did refer to a personal rights in terms of the agreement. Mm-hmm. So he's saying that is strange. Are you able to explain why he would have done that in the light of the risks that he has already articulated?
Oh, okay. All right.
And I think I would add, because you did say that he is involved in a lot of properties. Now, somebody involved in a lot of properties would know definitely that if he really has an interest in that property, he should have rights in the property. So that, despite that probable knowledge on his part,
okay,
he decided to agree to an arrangement which did not involve such a right is strange. Are you able to say why that is not strange as you see it, or it's strange but it should be understood in a certain context?
Okay, maybe maybe my mistake is to try and answer for Mr. Sodi.
Well, you're not answering for Mr. Sodi. You're answering for yourself, because you see this transaction occurs between you or your family trust and Mr. Sodi about 4, 5, 6 months or so after Mr. Sodi's company has been given the job that it was given, if you look at the service level agreement when it was signed.
All right. Maybe, Chair, it could be in the manner of the commitment that I put, or the risk that I've placed myself in the property, the investment part of it, to say I'm more than him in terms of the proportion in that particular property. The suretyship and so on. Now that and further that one has, until such time we have come to the end of the term, for lack of a better word. In other words, end of the term of the 7 years, or when I have ceased or kept away from, putting the trust at risk, either by trading and so on. That I've not done with the trust, that the trust also commit further in terms of its obligation beyond what it has, beyond what it has done. The major creditor of this trust, of course, is the bank, and it has also built up some sort of equity through I will say, through acceleration of payments on my side, so that there's neither risk for myself or for the investor. So that perhaps could have been the reason, so
But
to speak.
do you accept the proposition that this is strange, that he was prepared to agree to an arrangement in terms of which he would have no rights in the property itself? His rights would be limited to personal rights in terms of the agreement. Do you accept that that is strange, particularly for somebody who is quite involved in properties?
Well, I've put up the proposal and he has accepted it,
Yes.
Chairperson. So,
Yes.
you know, it was upon him to say, no, this is further what I wanted.
Yes.
You know, and so on.
Yes.
Different investors will have their
Mr. Pretorius.
Mr. Mokhesi, if one looks at the documentation relating to this arrangement and agreement, and assuming that it is genuine and not just a cover for a donation to you, and that's an assumption that is made here for the purposes of these questions, but it is not accepted certainly by the legal team as necessarily a correct assumption. You were able to buy a property in which you were to reside now for at least 5 years, worth at that time 1.6 million rand, when you could only raise a bond of a million rand, correct?
Yes, 1 million.
Not only did you enjoy personal occupation of the house, but also you enjoyed the benefit of what you've described as a potentially profitable investment after 7 years. Correct.
Correct.
Which you would not have had, either of which you would not have had Mr. Sodi not invested 650,000 rand in the scheme. Correct.
Yeah, but that's an investment, Mr. Pretorius. I think I've made that point to say it is a commercial transaction.
Yes, but had he not made that investment, you wouldn't have enjoyed residence in that house for 5 years.
I'm sorry, Mr. Pretorius. I think Mr. Mpofu wants to say something. You can say it from where you are.
Oh.
Yeah.
Thank you. Chairperson, I've left this for a little bit because I didn't want to interrupt Mr. Pretorius. But I think now we're getting into the
area that
yes, because it's clear what Mr. Pretorius is doing. The witness might not be aware. He's now establishing an element of a crime, which is a benefit or potential benefit. And that is exactly where we are not supposed to go. Of course, he's not dealing with other elements like mens rea and so on, but we all know that this is a crucial element of some of the things that are being investigated, allegedly investigated.
Well, just 2 points, Chair. The first is that there must be a positive assertion that this is an incriminating question, and reliance must be made on that assertion. So what Mr. Mpofu has said appears to assert that, and one can accept that.
You confirm, Mr. Mpofu?
Yes, I do. I do confirm that.
Okay.
Well, that's the crux of the objection.
Yes.
Okay.
The second is we've done our homework in relation to this and other matters. You will know the publication of BIA on commissions of inquiry. It's an international leading publication where he deals with the question of incriminating issues or questions. In order to be fair to the witness, it goes further than simply, did you commit a crime, yes or no? Such a question that might elicit elements of an offense or lead to further investigations which may expose an offence is a grey area. But yes, it is an incriminating question insofar as it seeks to establish an element of a crime.
Okay. Then I guess that was not your last question.
No.
Or was it?
No, I've got
Yeah.
more questions.
Okay. Okay, then you move to other questions then.
And I'm quite clear that Mr. Mpofu didn't do that to cut me short in any way. Okay, let's leave aside the issue of benefit. I think the question has been answered in any event. The issue is now whether it can be used against you. The agreement itself.
Let me ask this question, if Mr. Pretorius, before we proceed. Mr. Mokhesi, you did say that Mr. Sodi has a lot of properties in which he is involved. Do you know whether he has a property development business, or is it properties that he just buys?
Yeah, what I've he invests in properties.
Yeah.
You know, in various areas.
Yes.
I know
Okay.
that even in the Free State, he has invested in some properties. And
Okay.
I think in the Western Cape, in Devon, and so on.
Okay. Your voice is too
Sorry.
low now.
Yeah,
think it's,
I'm saying I know that he invests in properties. Right. He is I know that he is in Free State. He has invested in properties. I think as well in the Western Cape.
yeah, your voice goes down.
And so on.
Yeah. Okay. You know that he invests in many properties. Is
Yes,
it right?
Yes.
Okay. He could have invested in any property that he liked in the area where this particular property is on his own without you. Do you know, or do you not know whether he could have done that on his own?
I honestly don't know whether he could have done it on
Yes.
on his own.
Yes. Well, you see, when one looks at the agreement that the two of you concluded, one gets the impression that he wasn't bothered about this 650,000 rand. He didn't bother to say, I must be one of the owners of the property. He paid the 650,000 rand, and on the assumption that this agreement is genuine, concluded this agreement, and maybe basically to assist you. Otherwise, he didn't need to have any to invest in any property with you. He could have invested on his own, as he has done with other properties. And maybe he was assisting you.
Well, there are properties where he has
Chairperson?
Sorry? You say even the chairperson.
Yes, I think Mr. Pretorius will have to be the adjudicator now, because I'm objecting to the question of the chairperson. I think, Chair,
Yes.
in fairness, I understand what the Chair is trying to say, but it amounts to the same.
Yes.
The
Okay,
same.
okay, no, that's fine. You don't have to respond to that. Mr. Pretorius?
Yes, I'm entitled, Chair, to answer questions insofar as they reflect on Mr. Sodi's conduct.
Well, I'm sorry, Chair. Of course, Mr. Pretorius is correct, but in relation to the question of self-incrimination and so on, but what I would object against is for him to ask this witness to speculate on whatever was happening in the mind of Mr. Sodi. As I say, outside of the main issue, which is the self-incrimination issue. It's just
Yes.
a waste of time because it's
I
not
th- I
going to
think
assist anybody.
I think let's wait until there is an objectionable question.
Yes.
Yeah.
All I intend to do is to put to you certain clauses of the agreement so that I can understand what you say about those clauses, which I would wish to do, and if there's an objection, we can deal with it at the time. If one goes to FS1 at page 89, you'll see there that is the agreement. FS1, page 89.
Time flies. I see we are at 2 minutes past 1. But I think we are close to finishing, aren't we?
Well, public protector findings, I
Yes.
will be very brief in my question.
Yeah.
That I can undertake.
Okay, maybe let's continue. What's your estimate?
Of how long my questions will take.
Yeah, and
They will
answers.
take a very short time, 5 to 10 minutes, but it's the answers I can't control.
Yeah. Okay, Mr. Mpofu, I think let's try and continue.
I would be very indebted.
Yeah, so that when we take lunch, we are done with Mr. Mokhesi.
Yes,
Thank you.
thank you.
Okay, all right. Let's do that.
Let's try and move as fast as we can.
Well, I know that there's a time when I allowed Mr. Mokhesi quite some leeway in explaining. I did so deliberately. I could have cut him short, but I thought it's an important part, at least for him to give that explanation. So, but in order for us to try and finish reasonably soon, I might interrupt and keep him to
Yes.
the questions.
And I will try and avoid questions that are merely putting the exact issues I want to raise in their own context, and
Yeah.
I'll go directly there. Paragraph 2.5, Lekemo shall be entitled to rent the property to whomever it so desires. Was the property rented to anybody?
No, it was not
Did you
rented.
pay rent?
As I've indicated, all that I'm doing, I'm paying additional.
Right, so you didn't pay rent.
I did not pay rent, but I'm far. There are expenses that I'm carrying.
Paragraph
About that.
2.7 says what will happen if the property is not sold within 7 years. Now, Mr. Sodi has given evidence in respect of this, and it needs to be clarified. If the property is not sold within 7 years, then Lekemo shall pay Blackhead its initial investment of 650,000 rand, its proportionate share of the rental income, less any expenses incurred for the maintenance of the property. Now, we know there's no rental income, correct? You'll have to say yes.
Yes, yes.
And 3, an amount equal to 65,000 rand per annum in respect of the notional capital appreciation of the property, correct?
Correct.
If, however, and I'm referring to 2.8 now, if the property is disposed of, sold, and that must happen by mutual agreement, each party shall receive their initial investment. The parties agree to share the capital appreciation, and the parties will share any rental income, less expenses. Correct.
Correct.
But again, we know there's no rental income. Of course, there's an anomaly in paragraph 2.7, which says that if the property is not sold, Blackhead is paid out, and it says whereafter the trust shall retain full ownership in and to the property. Of course, it's always had full ownership. We know that. Correct.
Correct.
There's a clause, and the import of those clauses are a matter for argument and submissions, and we can deal with that independently. Paragraph 8. The parties confirm that the terms of this agreement and the negotiations leading up to its conclusion are confidential and will not be disclosed to any third party. Why was it necessary to insert that clause?
I'm sorry, what clause is that?
8.
8, okay.
Well, Chair, I took this as a standard agreement between two in any way, it does not in any event exclude parties like commissions or legal, but not private parties.
It appears to exhibit an intention to keep the terms of this agreement secret. Otherwise, all you would see is what you would see in official records. And we've dealt with that.
Only for the people who are. The commission is, for example, this is why I'm making an example. Commission is entitled to this information, right?
I'm not saying it's been breached. What I'm asking is why have it in the agreement in the first place, if not to keep this agreement secret?
Sure, I don't know.
No comment?
No comment.
Let's then move to the findings of the public protector. They appear in bundle FS3. It's not necessary for you to go there. Let me just introduce this series.
Before that, Mr. Pretorius, I'm sorry. Before that, this agreement, Mr. Mokhesi, as I said, was concluded about, 5-6 months after the appointment of the joint venture to do the job.
Yes.
Now, there was a part of the job that had not been done, namely the removal of asbestos. So this agreement was entered into at a time when Blackhead had been appointed to do a job that had 2 tasks. Let us say it may have finished doing the first part, but it had not started on the second part, namely the removal of asbestos, isn't it? And as far as you knew, at the time you took it that they were accredited to do the second part of the job. So was it not problematic for you to do that?
At the time.
In other words, my question is, as HOD, was it right for you to enter into this arrangement, even if you were doing so through your family trust with Blackhead, in circumstances where Blackhead had been appointed by your department to do a certain job, the first part of which they may have finished, but the second part of which was still to be done?
Chair, I'm sorry.
Yes. Is it one of those?
Yes, it's one of those. The first part is quite, to be fair to you, Chair, the first part where you obviously are establishing the sequence, I think I can't object to that.
Yeah.
But the second part where he either has to say that he was culpable or not, then clearly that...
Well, maybe if we don't look from a legal point of view, let's look at it from an ethical point of view. How is that? From an ethical point of view, Mr. Mokhesi, was it fine for you to enter into this agreement in these circumstances at that time?
Well, this was a commercial transaction, Chairperson. Inviting somebody to come and invest with you on specific terms which are purely commercial. And that individual could either have said yes or no, I'm not interested, because it was purely commercial from that point of view.
But are you entitled to enter into such a commercial transaction ethically as head of department with an entity that was in this position, such as Blackhead at the time? Namely, it had been appointed to do 2 tasks. It had done 1. There was still a task that it was still going to do.
So the chair is saying on a commercial, whether
from an ethical point of view as HOD, was it ethically appropriate for you to enter into this commercial transaction with a service provider to your department who, one, had done the first part of the job, but was still to do the second part?
Okay, one was at that particular point in time, I think when we went to the second, indications were that we would not continue, and I'll indicate what came out at that particular point in time. It was the differences in prices, the irregularity at that particular time was already flagged up, not in terms of the other issues, but in particular in terms of the 650 versus the 850. So from our point that, it would have ended there and not continue.
What would have ended there and there?
I'm saying the first phase and not the second phase.
Yes.
Because it turns out, that 650 versus the 850 thing rendered the whole thing irregular.
Yes.
The entire, even though we later learned that these other factors also came into play.
So, are you saying that at the time you entered into this commercial agreement, as you call it, with Blackhead, you were aware, you had come to the conclusion that the contract was irregular, the contract with Blackhead to do this job, and that therefore it was not going to, phase 2 was not going to be done.
Phase 2 was not going to do, but also, Chairperson, also the issue that I've learned, where I learned that this particular individual is involved in investment in properties. And I had already, as I've indicated earlier on, I did not start with him.
You did not what?
Start with him. I started with family members who are also involved in this particular investment in properties. As well.
Yes, okay.
So I learned in the process that he also invests in properties, and that's why I approached him.
Yes. Okay, let's go back to my question. I get the impression that your answer to my question is yes, it would not be ethically appropriate for you as HOD to have entered into this commercial transaction if Blackhead was still going to continue and do the second part of the job. Am I right?
Let me put it this way to perhaps maybe to assist. Maybe on hindsight, yes. Chairperson, to respond directly to her question, maybe I shouldn't have.
Okay. So you are saying on hindsight,
yes,
you think it was not ethically appropriate?
On hindsight.
On hindsight, yes. But at that time, you saw nothing problematic ethically about it, or did you see something
particularly because I saw this as a purely commercial transaction, and
yes.
and that's why it had to be recorded in that manner, and also my trusteeship as well be disclosed,
yes.
Also, yeah.
So at that time, you did not see anything wrong with entering into this transaction from an ethical point of view, is that right?
At that time, yes.
And that was because you saw this as simply a commercial transaction?
I saw that as a commercial transaction, and also the disclosure of my trusteeship in the disclosure form. We are also, every year we are required to disclose our...
Yes.
Yes.
So the issue about whether Blackhead was still going to do or not do the second part of the job, namely the removal of asbestos, that was not an issue that influenced you in entering into the commercial transaction.
I was not influenced by that.
You are not influenced by that. But as a matter of fact, was that the position at that time, or is it something that arose later, namely that they were not going to do the second part of the job, namely the removal of asbestos?
Well, because of, well, as I've indicated, because we learned of the 650, 850 at a later stage, it came to my attention that Treasury was not approached of that, because that was the only thing that we knew. Plus, as well as, because what prompted that was actually when the investigation of the public protector started.
Yes. But you say that arose later.
That arose later.
Yes. So the only thing that made you believe that you could enter into this transaction with a service provider at that time was simply that this was a commercial transaction.
It was a commercial transaction.
But that reason, Mr. Mokhesi, doesn't sound convincing to me, because if that was a good enough reason, it would mean government officials could have these commercial transactions with service providers anytime, because it's a commercial transaction. Whereas my understanding is ethical is precluded, because you don't want any perception that you may be doing favors for a particular service provider because of any transaction or arrangement or closeness that you may have with them.
Chair, I appreciate where you're coming from. And I've indicated that on hindsight, right, because I indicated it was a commercial transaction. My trusteeship was declared. I had no intention of hiding that transaction. It's auditable, or it's traceable, for lack of a better word. And one wanted to keep it in that particular level of a commerce transaction, so that you deal with it in that particular case, in an event that anything happens. And I contributed substantially more in that particular as well, in that particular transaction, just to show what is it. But maybe on hindsight, I shouldn't have.
You see, I have some difficulty in accepting, maybe later on when I have more time to look at everything, I might not have the difficulty, but I have some difficulty in accepting the reason that you give as justification for entering into the transaction. Because I'm thinking, if any of your officials had come to you and said, I want to have this kind of transaction with Blackhead, while Blackhead was doing business with the department, and they came to you as HOD for advice, wouldn't you have said, no, you can't do that? Would you not have said that?
Yes.
Chair, I'm sorry.
Okay. Mr. Mpofu.
Yes, no, I object to that question, Chair.
Yes.
Not so much, again, on the technicalities.
Yeah.
But in fairness to the witness, Chair, and of course I don't want to be putting words in the witness's mouth. The witness has indicated, Chair, that the issue of disclosure, which is very important, at least in the area that we're discussing now of the ethics of, and it's a gray area which is almost always misunderstood, Chair. That the duty is not so much not to do something always, rather than to disclose it if you've done it, so that, let's postulate what the chair was talking about earlier. If the second phase, let's assume the second phase was still going to be tendered for, then Mr. Mokhesi would have had a duty not to sit, for example, in that decision making on the basis of the disclosure that he would have made. And not so much that he must not greet or speak to someone or not even do a commercial deal if he wants to, but he must, as long as he knew the ethical consequences would be that, then he would not be able to adjudicate on anything. That, so it's an objection.
I understand what you say, but you know, as the HOD and the accounting officer, I expect that from time to time officials would come to him for guidance. So I just want to see how he would have. Yes, thank you.
Yes,
How would you have advised an official in your department saying, HOD, I'm sorry, let me finish. HOD, here is my situation. I want to do exactly what you did. I want to do it, but the service provider has a relationship with the department and so on.
Well, it does.
I don't want to do something wrong.
Chair, I also don't want to, because it has never happened in my experience. It has never happened. However, what normally happens is the disclosure part of it, where you then pick it up, because normally the adjudicators of that particular thing will be the Public Service Commission.
Yes, but remember, he is coming to you before he enters into the transaction. He is coming to you before he enters. He wants to know whether he is precluded from entering into this transaction.
It has never happened.
And what is the position of the department?
It has never happened that somebody comes and I'll want to know any DG or HOD who said staff members has come on this particular thing. All they have to comply, because there are rules. All they have to comply with are the rules that are set out in terms of that. And then you measure that against those particular rules.
And would the rules permit him to enter into this kind of transaction, provided he discloses, or would they?
Yes, there are disclosures that you have, because you also have to you have to disclose. Right? Now, I think lately there has been a rule that says you can't do business with the state, right? As I say, but before you could. Provided you disclose, you know, and those are the developing trends over time, and so on. Now, to ask me that question in a way, you know, is actually unfair to me, because it does never happen. You can put any HOD or DJ.
It calls for your knowledge of the rules or policies of the department to say, as HOD, I know that we have a policy that says ABC about this, or I know our policies don't say anything about this, or I know they say you may do it provided you do this or that. That's what the question calls for. But if you say, look, I don't know what my advice would have been, that's what you can say.
Yes.
You don't know what the answer would have been. Okay, Mr. Pretorius?
2 points arising out of that, Chair. The first is that we know that at the time the agreement between Mr. Sodi and Mr. Mokhesi, or his trust, was entered into, payments were still continuing in relation to the so-called first phase, if that reference can be made. And they were being continued in controversial circumstances, and we've heard evidence about that, notwithstanding, for example, the Auditor General's findings of irregularity of the underlying agreement. So that's the first issue. It's a matter of record. We needn't take it further. But the second point is a more general point, of course, Chair, is that it's a matter of concern to the Commission and the evidence leaders, not only that this conduct might be criminal activity, but it appears from evidence, including this evidence, but other evidence as well, that it's very easy to disguise a transaction. It may be a transaction that is said to be a deposit on a car, or a repayment of a debt, or payment of a debt accumulated in a pub. There are various ways that it can be done, and it seems that a line must be drawn where, as a matter of policy, this type of activity is not allowed, whether legitimate or illegitimate, to avoid this type of matter happening. So if I may move on to the public protector issue, Chair.
Yes. Who prepared this agreement for you, Mr. Mokhesi?
Chair, I made an input on this agreement, and I gave it to Mr. Sodi to finalize and make an input as well.
There was no lawyer involved?
No,
As far as
certainly
you know.
not from my side.
Yes, okay.
Certainly not
So
from my side, because
he
I was
ultimate-
inviting him.
So
Certainly.
Mr. Sodi was ultimately responsible for putting it together with your input?
With my inputs.
Yes. Oh, okay, all right. On the disclosure, Mr. Mokhesi, is it correct that the disclosure you are talking about is the disclosure within your department?
Yes.
Is that right?
Yes.
Yes.
My trusteeship in the department.
Yes.
My trusteeship in the trust.
Yes. But what you disclosed was that you are a trustee of your family trust. Is that right?
Correct.
You did not disclose that you received, that you did not disclose that Mr. Sodi had made this contribution in this commercial transaction, of which the family trust was in
No,
which it
but
was involved.
Chair, this is not in my personal capacity.
Yes, it's in
Right.
it's in your,
Because an impression here is created that I received it
yes,
in my personal capacity.
yes,
Right. Now,
Yes.
this is a joint venture between, okay, maybe
a commercial
a
transaction.
commercial between two individuals.
Yes.
I hold a trusteeship,
Yes.
and I've disclosed who the trustees, including the beneficiaries, are in that trust, plus the number, because you also have to disclose that particular issue. And from time to time, the commission, the public service commissions do investigate all this. Once you disclose whether it is your membership in a company and so on, they do independently investigate those and a few months later they give out a report about what is that?
If the family trust had not been used in this transaction, and you had entered into this arrangement with Mr. Sodi in your personal capacity, would you have had to disclose in the department that there was this arrangement?
Chair, I would not, you know, my marginal tax rate is 45%. Okay. Now, I can't use and receive the money directly. You know, you have to use some sort of a tax efficient structure in a way, because I'm at the highest at 45%. And this might be, if it comes directly, and this is what informed the formation of a structure like that in the main, right? Number one. Number two, and also you don't want to mix up, because I also have assets and properties in my personal capacity between myself and my spouse. Now, if you bring in the third party in this type of
Okay, Mr. Mokhesi, what's
right, maybe
the
I'm
answer
talking
to
too
my
much.
question? Is it yes, you would have had to disclose it if you had entered into it in your personal capacity, or is it no, you would not have
Yes,
had
no,
to?
you have to disclose
You
it.
would have had to disclose
In a
it.
personal, like
Yes.
and like all others that are in my personal capacities that I'm
Yes.
disclosing.
So one advantage of using the trust to enter into this transaction is that you would not have to disclose this amount because you didn't get into the arrangement in your personal capacity.
It's
Is that
not
right?
an advantage. It's not an advantage. It's a commercial to say.
But Mr. Mokhesi, it's an advantage because you told me that you could not get a 100% bond. You needed a place for accommodation. The ABSA could not give you a full bond. You needed somebody in order to get accommodation beyond 1 million rand. You spoke to Mr. Sodi. This arrangement was done. You were then able to live in the house. That's a benefit, isn't it? That's the advantage otherwise you would not have had. Mr. Mpofu.
I'm sorry, Chair.
Yes.
I thought my day was going to be easy, but it looks like it's not. Chair, with the greatest respect, that's exactly the question that Mr. Pretorius refrained from asking.
Yes.
That you are putting about the benefit.
Yes. Okay. No, I will not insist that he answers it. Yes, Mr. Pretorius, continue.
There is a related question which is not prohibited by the regulation, Chair, if I may ask it. Mr. Mokhesi, how many of the other beneficiaries or trustees enjoyed rent-free accommodation of the property?
I'm the only one staying in that house. I'm the only person who stays in that house. I've indicated that that is not my primary residence.
Let's move on to the last issue, if we may, Mr. Mokhesi, and that's the Public Protector's findings. I certainly don't want to invite long debate in reviewing the Public Protector report. But the Public Protector did make certain findings, and if you wish to highlight anything, any fact that you might be aware of to challenge the particular finding I'm going to put to you, you're of course free to do so, and it's fair to give you that opportunity, because no doubt the Chair will take account of the findings. So I'm going to put to you several findings, and you can just say no comment, or yes, I know a fact that calls that into question, or I agree with the finding. Okay?
I think Mr. Mpofu seems to want to...
Yes, Chair, again, I don't want to stifle Mr. Pretorius, but he can make a choice, so it's not a formal objection. But for the record, the witness does not wish to challenge any finding made by the Public Protector or comment on it at this stage. If he wants to review the Public Protector's report, he'll do it like everyone else. So I don't see the futility of reading the report to him.
Well, if, Mr. Mokhesi, you're happy with that statement, I think in any event you're bound by law, by your representatives.
It's binding anyway.
That you don't want to challenge any of the Public Protector's findings, we can leave it there.
Yeah, I take legal advice. That's my counsel. So,
and you're paying him.
And the law says you're bound by what he said.
And you're not paying him peanuts.
Well, Chair, I'll take the stand on that.
Right, then I don't have further questions.
Yes.
Thank you, Chair.
Mr. Mokhesi, I just want to make this comment, and you may want to say something, you might not have something to say. Incidentally, I seem to see some parallel or common features between what you said in relation to the disclosure of the question of disclosure of your trusteeship or non-disclosure of the amount, because as you say, it was not a personal thing, with the evidence of Mr. Vincent Smith, who gave evidence here some weeks ago, You might or might not have listened to his evidence, but
Mr. Who?
Mr. Vincent Smith, he's a member of parliament, or was a member of parliament, I'm not sure. He, while he was in parliament, on his version, he had entered into a loan agreement with Mr. Agrizi of Busasa for a certain amount, so that he could use that amount to pay for his daughter's studies overseas. But he said that amount should be paid into the account of his company, not to him personally. That was done in regard to, I think, at least one amount. But from the Busasa's part, when their lawyers sent that amount, they said it was in regard to an accident, a car accident settlement. But he insisted, he said he had disclosed the company which received the money in his disclosure in Parliament, disclosure of documents in Parliament. But he had not disclosed the amount. So in your situation, you had disclosed your trusteeship of the family trust, but not the amount on your side, because you say you were not getting this money personally. So I'm just saying there is another case there, or another witness who has given evidence which seems to have some similar features, at least to some of the features of your evidence. And incidentally, on your version, your commercial transaction with Mr. Sodi of Blackhead was entered in 2015, and you say it was for, there was the arrangement that after 7 years, the property could be sold. So he too, he said his loan with Mr. Agrizi was entered into in 2015, and the repayment was going to be to happen after 7 years, which is 2023, same 2023 as yours. So I say nothing. I'm just saying I'm observing just certain features. You might not wish to say anything,
Yes,
Mr.
Chair, he does not wish to say anything.
Yeah.
No,
Okay,
Chair,
all right.
on a serious note, I hear what the Chair is saying, but I mean, I don't know, maybe Mr. Smith's thing amounts to a criminal offense, so I would not advise him to comment on any
that's
alleged
fine.
similarities.
No, that's fine, that's fine. Do you wish to re-examine or no?
No, Chair.
Okay,
Thank you very much, Chair. No,
okay, all right. Mr. Pretorius, you are done.
Yes, Chair. Safe to point out that the value for money issue was clearly found by the public protector against the department. Public protector found no value for money.
Okay, all right. I think Mr.
But that's
Mokhesi
now
might have mentioned that as well.
Well,
Okay.
Chair, now Mr. Pretorius is provoking me.
He's provoking.
Chair, my understanding was that he's partly right. My understanding was that, as the witness stated, certainly there was some value for money. Whether it amounted to 250 or not, that's a debatable issue. But certainly it's not as if there was just money that was thrown out. There was some work that was done. But I'm sure that's what Mr. Pretorius meant here.
Okay.
Well, the finding remains unchanged.
Yes. We are at 22-2. Mr. Mokhesi, thank you very much for coming back to give evidence. I will excuse you now, and if a need arises for the commission to request you to come back, I'm sure you will come back. But thank you very much, and thank you to Mr. Mpofu. We are going to adjourn for lunch and resume at 22:03. We adjourn.